Well, welcome everybody. It's 2:46, and well, Theo's coming in. We'll let Theo in, and then we'll get rolling. Um, Thanks for joining us today for MLSA's 60th annual conference. Kind of a different way of doing it virtually, but everybody's figured out how to do it by this fourth session. So real glad to see you here. And thanks to our sponsors for making this all free for us. It really added, we got a lot more people because it's free, and we have the sponsors to thank. My name's Mike Gallagher, and I'm with the Michigan Lakes Streams Association, and I'm the board. And you're in insurance and liability for riparian associations and homeowners, and that's going to be presented by Mark Teicher. You probably have noticed that your video and microphone has been turned off, and that really helps to make the presentation quieter and for the screens to move quicker. And so thank you for doing that. If you need to ask a question, please feel free to use your chat button at the bottom of the screen and type the question in. We will answer those questions, or Mark will, at the end of the conference, or at the end of this session. So today, our speaker, Mark Teicher, specializes in negligence, injury law in both state and federal courts. Mark has been practicing law for 39 years statewide. He has been elected and appointed to various state bar of Michigan positions over many years, and has won various recognitions and awards for his work. Mark has also served as a magistrate judge and a hearing officer on attorney ethics. He is also a professional mediator and arbitrator. Teaches law at the local community college, is president of his local Lake Homeowners Association, and as board member for Michigan Lakes and Streams Association. And he's one of all the board members work hard, and Mark really does. So he's a heck of a volunteer. We're lucky to have him speak to us today because he's super knowledgeable about the legal stuff involved with insurance. Mark, you've got the floor.
Okay, so Mike, if you can go to the first slide. And thank you for the present statement about me. Here we go. So to talk about insurance issues and liability as a homeowner, as a boat owner, as an association, let's first go over some basic things about negligence and why you need insurance issues. So this is the law in Michigan regarding negligence and child safety. So first, the definition of negligence. One reason we buy insurance is negligence is the failure to use ordinary care. Ordinary care is the care a reasonably careful person would use. This means that negligence is the failure to do something that a reasonable, careful person would do, or the doing of something that a reasonably careful person would not do under the circumstances. So it's basically keeping a certain level of care. If there are children around, it makes it even a higher level of care for the homeowner or for the boat owner or for the association. And that is as follows. The law in Michigan recognizes that children will act childish, with childish instincts and impulses. If you as the adult or me knew or should have known that there would be a child or children, then the adult, you or me, is required to exercise greater vigilance and is held to a higher standard than just a reasonably careful person. The type of example would be, since we're talking about associations and homeowners, is if you have an event as an association and you are strictly, you know that there's just going to be adults, then your standard of care is the ordinary care that an association board or a homeowner would give. The difference is that if you are particularly an association and you know that children are invited, you have to be extra special in your care, whether it's wires down on the ground for extension cords, whatever it might be, it's a higher standard. Next slide, please. Okay. So here are some examples of a little change in that definition of negligence. So when the negligence is in violation of a statute, well, Michigan law says that if an adult violated a statute before or at the time of the injury or damage occurrence, then it is inferred that the adult was negligent. What does this mean? This means that if you are the association and there is a statute means Michigan law, and you violate that law, then you are inferred legally to be negligent because you have violated a statute or a law. Okay, negligence when it's of an ordinance. An ordinance would be, if you're an association, your township. If an adult is in violation of an ordinance before at the time of injury or damage, then the violation is evidence of negligence. As opposed to a legal inference, then it's simply evidence if you have violated a township ordinance. Negligence when it's a violation of a rule or regulation. It's a little different. If an adult or an association is in violation of a regulation before at the time of the injury, then the violation is evidence of negligence again. So the difference with that might be that if your county health department has ordered a specific rule or regulation to take place, it might be evidence of negligence. Next slide, please. So here's more negligence. I get a lot of questions from associations. Well, what if we allow there to be alcohol, not drugs, but alcohol? According to Michigan law, one who voluntarily impairs his or her abilities by drinking or by drugs is held to the same standard of care as a person whose ability has not been impaired by drinking or drugs. So this would be if in fact, whether you're the homeowner and you decide to drink, or if you're the association board president and you decide to drink, your drinking does not affect the standard of care that you owe everyone. Gross negligence, a specific term in the law, means, Michigan law, means the conduct or the failure to act is so reckless that it demonstrates a lack of concern of whether the injury or damage will result. Okay, so someone just asked me for examples for an association. Let's go, if you go back on the slides one, Mike. And I know Mike said the questions would be at the end, but while I'm here. So if in fact your association has an event and you let adults and kids go on the association sailboat, if in fact, and sometimes I'm the worst case scenario guy, if in fact the sailboat tips over and someone drowns, God forbid, negligence would be if in fact the association did not make everybody wear life jackets, which is state law. Let's say it's state law. I know it's state law for kids. I don't know about for adults, but if it was state law for someone under someone a minor to have to wear a life jacket and they drowned, it would be inferred that that violation, whoops, where are we going? Okay, that violation of the statute would be negligence. If in fact it wasn't a state law that adults had to wear a life jacket, but in fact, let's say your township said adults had to wear a life jacket, then that would be evidence. The key here is, and we'll get to it a little later, why I bring all this up, is that in insurance policies, and I will present some insurance policies at the end, that whether you're a homeowner association, whether you're a homeowner where you have water or not, but particularly if you have water, if you have a boat and you have a dock, that your insurance policy says that there's coverage, except, and there's a lot of exceptions, and one of the exceptions is if you have violated the law. So one of the scary things is if in fact your association or you as a homeowner violated even just a township ordinance, you may not have insurance coverage. Now we can move forward with the slides, please, Mike. Okay, one more.
Yep. Mark, I'm sorry, I went the wrong way.
Okay.
More negligent.
Well, at
Is
least
that where
you're
you
not,
want to be?
at least you're not driving a car, so it's okay. You go the wrong way.
Yeah.
No, go one more slide forward, please.
Okay.
Okay, so going on some more definitions, wanton misconduct, and a lot of these terms I'm using, whether it's gross negligence or negligence, are in your insurance policies, the insurance contracts we're going to look at the end. Wanton misconduct means conduct or a failure to act that shows such indifference to whether harm or damage will result as to be equal to a willingness that harm will result. So if you see magic words in your policy that says, if there is wanton misconduct, we will not provide insurance coverage, this is what it's talking about: conduct or a failure to act that shows indifference to whether harm or damage will result. Proximate cause is another word often in the insurance contracts, which means that the negligent conduct, whatever was done wrong, must have been a cause of the injury or damage, that the injury or damage must have been of a type that is a natural and probable result of the negligent conduct. So proximate cause, for example, the association doesn't require anyone to wear a life jacket. They go sailing, or even not sailing, but someone's just swimming and a child drowns and they're not wearing a life jacket. That would be it doesn't have to be the only proximate cause, but that would be a proximate cause, the connection between the injury and the negligence. Okay, next slide, please. As a homeowner or an association, you owe different levels of safety to different people. An invitee is often referred to as a business invitee, a licensee, or a trespasser. So these words are also used in the insurance contract and can exclude you or not. So an invitee is a person who's invited to enter or remain present on your land, on your boat, at your dock for commercial purpose. Business purpose, typically. A licensee is when you invite your friends over. A social guest is how a licensee is often referred to. A trespasser is someone who comes onto your land, onto your boat, onto your dock, and you have either expressly said you can't come or it's implied that you can't come. So even if you don't put up a sign that says no trespassing, people can still be determined to be trespassers. Next slide, please. So what duties do you owe to these different people? For the invitee, so this is, you've invited someone to come to your property to discuss a business proposal and you're sitting on the dock, you have the duty to use ordinary care to protect the invitee from risks of harm from a condition on your land, on your boat, on your dock, if the risk of harm is unreasonable, or that if you knew or should have known or realized that there was unreasonable risk of harm. What should this mean to you? This means that if on your dock, and it's an old wood dock, and all your boards are nice and even and hammered down, and one is sticking up 2 inches, and it happens to be where your water is 8 feet deep right at the end, and you know that's sticking up and you mean to hammer it down and you don't, and you have someone for business purposes come out, whatever it might be, and they trip and fall into the water, you owed them to duty to warn them of that, because you knew of this unreasonable risk of harm, not just tripping on the dock, which sometimes happens, but that there was a 2-inch board that was 2 inches up. Duty to a licensee. Again, a licensee is the social guest. You have your friends out. You're liable for physical harm to a licensee, to your social guest, if you knew or should have known or realized that the condition that injured your friend involved an unreasonable risk of harm, and that you failed to warn them, and that your guest did not know of that danger. Next slide, please. Forward, please. Sorry. Not backwards, forwards. Okay.
Duty.
One more forward, please. So then the last is duty to a trespasser. Back one. Thanks, Mike.
Are we there?
No, the other way one.
Yeah.
It should say duty to trespasser. There, no, one more.
Okay.
Okay.
All right.
Nope. Nope. Oh, there it is. Duty to a trespasser. So even to trespassers under Michigan law, you still have a duty. You still have a responsibility. You have a duty or responsibility to the trespasser to not act with willful or wanton misconduct that may injure the trespasser, or that you were aware or should have been aware of the trespasser's presence on your land, on your boat, on your dock, but failed to use ordinary care to prevent injury to the trespasser, or that you were aware of the trespasser's constant intrusions and the trespasser's activity involved risk of death or harm. Then you have a duty to exercise reasonable care to keep your land, boat, or docks reasonably safe as to not endanger a trespasser. What does this mean? This means that if you have a cottage and there's a lot of kids around, and there's kids meaning anyone who's I should say, for this example, if you know that somebody every night comes and walks out on your dock and sits on your boat, and you know that, and they're not invited, and whether you put up a sign or not, but they're trespassing, and even if you put up a sign, say no trespassing, and they come and sit on your boat or walk down your dock at night, and in fact, you can do the same example of the 2-inch board towards at the end on your dock, and they end up falling off and drowning, you might be held to have had a duty to the trespasser because you knew that they were out there on a regular or semi-regular basis, and you knew of the potential harm. Okay, next slide. One forward, please.
Did I go the wrong way there?
Other way, yes, please. So it gets a little worse on what duties you owe, not only to a trespasser, if the trespasser is a child, and a child is anyone under the age of 18, 17 years, 11 months old is a child under Michigan law. So Michigan law says if the trespasser to your land, to your boat, to your dock is a child, is a 17-and-a-half-year-old or less, you have a duty to exercise reasonable care to keep your land, your boat, your dock reasonably safe for a child if any of the following are true. And this would be any one of these things. The child was injured by an artificial condition. Artificial condition simply means something that's not there by nature. What might that mean? If you don't have a dock and the shoreline is just the shoreline and someone decides to swim on your property and it's just the way it is in nature and they drown, you may not be responsible. If you have a dock and they are injured off your dock, that's an artificial condition. Number two, you knew or had reason to know a child would likely trespass. That's my example that if in fact there's a lot of kids around and you know they come out, you know they hang on your dock, and you know that they hop on your boat, you then better be really careful that you make sure your boat doesn't have anything dangerous to kids on it. So for example, I can think if you are a fisherman and you leave out your hooks and your knives, fishing knives in your boat, but you know the kids go on your boat as a trespasser and someone gets hurt on your knives or hooks at 2 a.m, but you know that kids do this and you know that they come out, you might be liable. Number 3, you knew or should have known about the dangerous condition and realized or should have realized that it would involve an unreasonable risk of death or serious harm. Next slide, please, Michael. If the trespasser to your land, boat, or dock is a child, you have a duty to exercise reasonable care to keep your land, boat, or dock reasonably safe for a child if any of the following are true. 4, the child trespasser did not discover the condition or realize the risks involved in meddling with it, or coming within the area made it dangerous. 5, the usefulness to you of maintaining the condition and the burden of eliminating the danger were slight as compared to the risk to a trespassing child. Eliminating the danger being slight might mean that that board at the end of your dock that's 2 inches up that all you had to do was hammer in, it would be not a big burden to eliminate that danger by hammering it in. 6, you failed to exercise reasonable care to eliminate the danger or otherwise protect the trespassing child. Okay, next slide, please. Non-delegable duties. I put this in because I've had people say, well, you know, I have somebody put in my dock and take care of my premises. It's only seasonal. There's only a certain amount of liability that you can dump off onto others. Under Michigan law, it says, as an owner or possessor that you own it, of your land, of your boat, or your dock, whatever level of legal duties you owe, you may not delegate to others if you are ultimately legally responsible. And next slide, please. Okay, so here, let's go back one moment to that last slide. So my point in showing you all of these definitions is number 1, how it relates to the policies, and number 2, that particularly as homeowners on lakes, boat owners and dock owners, I just like people to really understand that there is a risk and that under Michigan law, you're liable. If you own a house in the suburbs where you have a lot and you don't have water, there's only a certain amount of risk that you have the same level of responsibilities as we've talked about. But when it comes to a boat or it comes to a dock, it's much easier to see terrible things happen because, of course, kids drown, people get hurt on sailboats, on motorboats, people get hurt water skiing. Under all of these scenarios, tubing, whatever, fishing, you have a lot of responsibility. Now we can go to the insurance contract. Next slide, please. Oh, and you know what? Let me stop. And Mike, could you check the chat and just read to me if there's some questions I should answer right now before we move on to the actual policies.
Yep. Let's see, we have a play set on common area property. Are we required to wipe it down to prevent spread of COVID, or should we post a sign stating the play set is not being wiped down?
Well, I would say that if, number 1, if you're going to wipe it down, that's great. I know that right after the playgrounds opened near our cottage, the public playgrounds, like at the Metro Park, they took down the tape, but they put up signs saying, the tape that it was closed off, saying, we are not wiping this down. So they were putting people on legal notice that it wasn't being wiped down. But I would tell you that that a few slides back, we talked about how it's different levels of negligence if you have violated a statute or a township or a other administrative requirement. If in fact you were to check and the state were to require that playgrounds be wiped down a half hour or whatever, I don't know what they've done. If there is a health code requirement to do it, our recommendation, the county health code, it might be the basis for that, then you have to follow that code or else there is negligence. The big question would be, we talked a little bit about proximate cause. So if a child gets the virus, proving that the virus was from touching a playground that wasn't wiped down may very well be a problem in proving proximate cause. But I would say that if you have a common playground, that you should put up a notice, in fact, that it's not being wiped down. And you might want to check with your local county health department and the state just to make sure that they don't have a recommendation. And I would tell you, whatever their recommendation is, you should follow. The recommendation might be just put up the sign. It might be to do nothing, but I would follow that. The same would be true if in fact your association, let's say your association wants to have a July 4th picnic, the annual picnic. And there's some concern that should we have the picnic relative to the virus? Will we be considered negligent? Will our insurance cover this? If in fact someone gets the virus, and let's say there is a state or county rule that says there can be gatherings of no more than 40 people, and you have 100 people, you have now, the association has violated a government rule that can imply or be evidence of negligence. One of the keys to remember is that if you're an association or an individual and you do violate the health code or a county rule or a state statute, insurance might say, hey, we're off the hook. So if for no other reason than for potential financial responsibility, you would want to check whatever the health code says. So can you have that July 4th picnic? I guess it depends what the state and the county health departments say. Yes, Mike.
Here's another one, Mark. If a lake association has contests like sailboat races, kayak, canoe, paddle boat races, how susceptible are they to lawsuits and under what conditions?
I would tell you that, and I just want to make sure I understand that it's not, the boats aren't owned by the association. I'm going to assume that's the case because the associations I've dealt with, they don't own any boats. They just run the races. I would tell you that there is potential liability if there can be some showing of negligence. Under the law, it is assumed that certain activities are somewhat dangerous. So if you're sailing or kayaking and the rule says everybody has to wear a life jacket, the association says you have to wear a life jacket, and people choose not to, Michigan law says, hey, if you don't want to wear a life jacket, then either you're going to share some of that liability or the liability is on you now because you've chosen to disregard the rule. So you've contributed to the overall negligence, and now you're at fault, or you're enough at fault where we're not going to hold the association liable. But there is potential liability. The next item we have is an actual copy of an insurance contract for associations, and the best advice, or one of the best pieces of advice I would give any association, is make a list of all the activities your association does and email it to your insurance salesperson. And the reason I say email it is that you want them to know in writing what you all do. And you should ask in writing, is this covered? If it is simply oral when you call your salesperson and said, by the way, we do sailboat races. And they don't, that isn't put down on the form that goes to the underwriter. Because if you think about it this way, the insurance company says, we're going to charge you a fee based on what we think the risks are. If you have signed an application and it doesn't say anything about risky activity, sailboat races, all it says is that we hold a July 4th picnic, we don't allow alcohol, whatever to make it sound as safe as possible, they're going to lessen your premium. It'll be lower, but also more things may be excluded, like a sailboat race. And there are different, a lot of different riders, and a rider for insurance purposes is like a separate, an additional piece of the contract that allows something else to be covered. So there might be a rider for sailboat races. There might be a rider for whatever it might be. Mike, any more questions?
No. Well, Mark, there are three more, and we have about 25 minutes left. Do you want to finish, or do you want to come back?
You know, why don't you give me the questions and I can ask them, I can at least answer them shortly and then go on.
Who's responsible on a private lake, private roads, no lake owners association, but has designated lake access areas? Who is responsible for those designed access areas? If there is a problem in one of those areas, who might be sued?
Whoever the owner is, whoever manages it. If it's private, meaning I don't understand what it means an association owns it or if a person owns it, I guess would be my question. But typically, Michigan law says the owner is liable, a manager is liable, whoever you've tried to delegate the duties to can be liable, as well as you as an association or an individual being liable. So if you're talking about if you're talking about someone's putting a boat in and someone gets hurt putting a boat in at a public access that's owned by an association may be liable based on some showing of negligence, for example, that that boat shouldn't be taken in at night, and the association doesn't post a sign saying boats can only be put in or taken out during daylight. And the association knows that people take their boats out at night, and ends up someone takes a boat out at night and gets injured taking their boat out. There could be liability, although it certainly sounds in this example that there'd be a shared liability.
Okay, you've touched on trespassing, but the question is, can posting no trespassing signs protect a homeowner?
It can to some degree, but the law that we talked about is the law in Michigan, whether you post it or not. And really the worst case scenario is when there's a child, whether a small child, that it doesn't matter if there's a sign, because not all children learn to read at the same age. And if there's a little child that wanders on your property, whether you have a sign or not isn't going to protect you. But I would tell you that having signs up would be, I think, some protection against trespassers 18 years and older, because then certainly they would have the knowledge that they're a trespasser, but you still owe the same duty to a trespasser. It may have putting signs up affects other things, but as far as liability, I guess I'd say would help. Yes.
Okay, if a lake property owner volunteers to assist a stranded motorist or a sailboat caught out on and in the lake, is that property owner liable if boat owner thinks he or she or their boat was harmed by the volunteer?
I've never run into that scenario, but I would say that if the rescuer is negligent in some way, for example, they have a small pontoon boat and they say, yeah, we can pull your boat that's going under, and actually they're way too small and they need a bigger engine or pontoon, and they end up damaging it or sinking, helping it sink or something. I would say yes, there's liability. Again, it's not automatic. There has to be a showing of what was the duty you owed, the duty of ordinary care that we talked about in one of the first slides, and a breach of that level of care.
Okay, last question that's here is, if we list on literature contractors who are licensed do say septic hauler, do we assume any liability for their work? I'm thinking they're saying if they said they're licensed, do they accept all the liability?
So I assume this is if an association says, here are some people in our area that can do septic or can put out your docks or whatever. I would say the general rule is no, you're not liable. Just because you say these are people that that some of us on the board have used. I'm not sure I would put in writing that someone's licensed until I actually saw their license. Because it's very easy to say you're licensed without actually being licensed. So I suppose as long as you've seen the actual license, an email of the license from the state.
Okay, so that was the end of the questions.
Okay, so we can go on now. So this is an example of a policy of insurance for directors and officers, are the association insurance. Next. Are you able to go to the next one?
Did you want me to hit the link at the bottom?
I'm not sure how Melissa put this on. Here, hit the link and let's see what happens real quick. Or else I can just talk about it.
I'm pretty sure that this is a 4-page document that I need to scroll through. It'd be much better to talk about it.
Okay, then I'll just talk about it. So let me all right. So the reason that I attached 4 pages of this, the document that I had by example was about 22 pages. The reason that I had included it because it was interesting, particularly for the exclusions. And in this general policy, some of the exclusions were things that I kind of have never even thought about. For example, one of them was any kinds of defamation or libel or slander. So if in fact your association in a email or in a newsletter says something bad about someone that might amount to libel or slander, so it's either orally or in writing, that the insurance policy totally excluded it. What do we got here? Okay.
Does that help? That's page 1.
That's page 1. Okay, we can scroll down that. So in general, what does, whoops, okay.
Cool.
You can keep going. Some of the policy that I wanted to make people know, whether it was your household policy or an association, is one of the items that's always required in the policy. It says that you have to immediately give notice to your insurance carrier if there's a claim. If you don't do that, that can be a reason for a claim being turned down. So a piece of advice, if in fact you have an association, someone gets hurt at a party, they infer they might be hurt, call your insurance agent. If in fact there's a claim, the insurance company's there. If in fact they don't make a claim, then they close their file. So typically what the association policy covers is for injuries or damages to a person or to a property at association events or on association property. What I was going for here, whoops, where it says who is an insured, the people who are insured under this particular association policy are not just the officers and the board of directors. But on this one, it said any member who volunteers is covered by the insurance. So I guess that would raise the question to me that if in fact someone's not a member and volunteers and gets hurt, and since a lot of our associations are voluntary, which might mean that people can come who are members and who aren't members, then you might want to check your policy to see if it says strictly volunteers who are members, or will cover anyone who volunteers. But this one said that it had to be volunteers who are members. The other thing about association policies that you want to watch for, and I'm not going to go through it, it's in one of the later pages here, is that this homeowners policy said that we are always secondary, or we have to pay second to a first party policy. What does that mean? If someone gets hurt who should have been covered by workers' compensation, then workers' compensation goes first. If in fact they should have been covered by workers' comp and they weren't covered, this policy says then we don't cover anything because you should have covered them with workers' comp. So you might want to make sure that whether or not you have someone who's working for the association who's getting paid, or whether or not you just have a vendor come in and the vendor sends some employees to, let's say, to set up the July 4th audio system, and one of their employees gets hurt, the association insurance is going to say, hey, that person should have had workers' comp insurance. So as an association board member, when you have vendors, you might want to say, email me over a copy of your workers' comp insurance. Okay. There was just a question that popped up on my screen.
Okay. Yeah. Is the policy needed for both Lakes Special Assessment District and its association?
No, typically the Special Assessment District does not have insurance, as far as I know. Typically, no. Although the typical special assessment district that I know of is run through a government agency, through a county or through a township, typically a county water resource commissioner. So there wouldn't be insurance. But so I would say at least an association. The other thing I'd tell you is that I get a lot of people who say, well, we want more insurance, but we can't get it for our association. And then I say, well, who are you calling? And they'll say, well, we have the same agent that we've dealt with for the last 15 years, and he's a friend of one of the board members. I'd say, try calling around, try calling somebody else. Another agent.
Okay, you see another question up there?
Yes. Does a statutory lake board need insurance separate? I believe the answer is no. But I'm not certain on that.
Okay.
Okay. So now we're to, I don't know how much time we have left, but Lakeside Living additional coverage just popped up. So let me talk about that since it's here. So
and we have 15 minutes.
Okay, 15 or 50?
15.
15. Okay. So Lakeside Living on the typical homeowners coverage, it doesn't cover certain things. Typically, the homeowners coverage, particularly if your cottage is your second home, it covers your home, it covers your buildings, it covers injuries to your home. But this Lakeside Living additional coverage, this is through auto owners insurance, is actually a specific rider, like we said, a separate addendum to the contract that says that this is insurance for your dock. This is insurance, particularly, I care about the dock. I have a dock that's 110 or 20 feet long, and it'd be very easy. And certainly kids and adults have goofed around and fallen off it. Luckily, no one's been hurt. But this is Lakeside Living is a policy where one of the definitions in this Lakeside Living is Lakeside personal property means personal property included but not limited to portable docks, floating docks, stationary rafts, ice shanties, water slides, floating trampolines, boat hoists, and any other equipment not permanently installed. Oh, there it is. So most people in Michigan, for us cottage owners or lakeside owners, have to take our docks out. So they would be covered by this policy. There it is under B. The typical homeowners policy talks about permanent, kind of like an A there, talks about permanent structures as being part of the house. So if you had a dock that's permanently in the water, that would be totally separate. So I would just say, go through your homeowner's insurance policy and call or email, particularly email your sales agent and say, is my dock covered? Okay, now we can go to the next slide. It should say Waterfront Advantage endorsement. Okay, Waterfront Advantage endorsement. So this is, whoop, where'd it go? Okay, well, it's not up on this. Can we get it up on the screen or no? Okay.
Try.
Okay. So this is another endorsement that is in addition to your regular homeowner's coverage. It's important if we can scroll down just a little bit. That's good enough. That where it says definitions, that includes floating items. So for example, if you have a floating dock, I'm always concerned with, you have the floating dock 50 feet past your dock, where you can go to either get away from the kids or send the kids, that what if a boat hits that at night? And this insurance called Waterfront Advantage endorsement specifically covers that. Again, just another issue, whether you're an association that owns a floating dock at your association beach, this would apply to not only, I believe, not only to homeowners, but also to an association insurance. Because often the association insurance, which is called sometimes D&O, directors and officers insurance, is insurance relative to directors and officers, but you want to really make sure that it covers property and particularly a floating dock. You can go on now. I think I had some photographs here.
Okay.
And I just wanted to give examples of pictures of liability. So as I look at these pictures, as I look at my dock, I see, oh my God, look, there's a dock where somebody can get hurt, somebody can fall off. There's a hoist where certainly as the boat goes up and down, somebody's finger could get caught. That's what I see. Isn't that terrible? I don't see it all the time. Okay, next picture. When you take people's kids or people skiing, there's a lot of potential liability there. So when you ask somebody, oh, do you know how to ski? And they say yes, and then it turns out they haven't skied in 45 years. And as soon as they get up, they whack themselves in the head with the ski. You really might want to ask somebody, when was the last time you skied? Which I did find out that skiing is covered under my boat insurance. So anyway, next. Animals. If you have a dog, that's wonderful, and I love dogs. However, Michigan law allows certain breeds to be excluded from your policy. Not that they have to be, but it allows them, and some policies exclude them and some don't. And some say, if you have a German Shepherd, the last breed here, you can have a German Shepherd, we're just going to charge you a little more. So these breeds are breeds that Michigan law would allow some insurance company to get off the hook on. So I would just say, when your insurance agent says you have a dog, you might just want to make sure you tell them what kind of dog you have. Next slide, please. Just another picture of friends out that that could be considered a dangerous activity, although it's fun. Next slide, please. There we go. And tubing is just like skiing. Next slide, please. At full moons, it is great, particularly to kayak in a full moon. After doing it a few times, I thought about it and thought, oh my goodness, this is maybe a situation I should think about, but I still do it. But if you haven't tried it, kayak at night, however, first call, check your homeowner's insurance. Next. If you so buy people food, here's some eggs from a local egg farmer, and whatever color of eggs you get, don't food poison anybody. This is really, I just wanted to show the different colors of eggs that I get by my fireworks, July 4th fireworks. It's really fun, and if someone burns their hand, you're on the hook, unless they do something really stupid, although then you still might be on the hook because it's known as a hazardous activity. Next. And there we go. So kayaking in the snow in the winter is wonderful. However, again, you're liable. And if you have friends out and you kayak in the snow, it can be an issue. And yes, when you fall in from your kayak, let me put it this way: the best thing about falling in when it's like this is that you're never really cold again. Let's move on.
Yeah.
If you are working equipment, let's say that your association owns a tractor and wants to get some work done, and there's whoops.
Yep. You got it.
Okay, there we go. That this is the type of thing where an insurance company is going to say, if someone comes in to do work for your association, you better make sure they have either workers' comp insurance or auto insurance. It's a motor vehicle, because your insurance company, if someone gets hurt, is going, you're either homeowners or your association insurance is going to say, those are the primary insurances and we're secondary. Okay. I think, is that any more photos? Anything else here? Okay, this is just showing off a fish. Okay, next. Oops. Let's move forward because I see there's a bunch of questions popping up. So we'll just
Okay.
I think that might be it. Okay, that's me. So anyway, if you can go over how much time do we have left, Mike?
We have 6 minutes left.
Okay, so let's go on. Questions.
Okay. Must the association enforce the behavior or simply state what is required? Kind of somehow require wearing life jackets versus stating, printing that life jackets are required.
I mean, the best case scenario is you say you can't go in the kayak race unless you wear your life jacket and enforce it. But I mean, that would be the best case scenario, but I know everybody doesn't always listen to what you as a homeowner or an association president says. Next question.
Okay, any comments about liability associated with accident injury involving boats and swim raft?
Well, under the Waterfront Advantage policy that I showed, I'm sorry, I think it was the other one. No, it was the Waterfront. Under the additional coverage, the endorsement, there were specific provisions for floating rafts. So my advice is make sure that you have some endorsement or specific language that says floating rafts are covered, because otherwise they may very well be excluded. Insurance contracts and documents have a lot of fine print that I think are reviewed by a lot of lawyers that all they do is write smaller and smaller and smaller. And a lot of times it says policies say nothing is, it's not covered unless we say it's covered, otherwise it's automatically excluded. So you really need to see in writing that something's covered. That's why I say, as opposed to calling your insurance salesperson, that you send an email so you're getting something in writing saying, oh yeah, it's covered. And although I greatly appreciate insurance salespeople, sometimes the salesperson has not a full understanding of what the policy may cover or not. Any other
Okay,
questions?
yeah,
How close are we getting on time, Mike?
4 minutes.
4 minutes, okay.
Oh,
It's getting hot in here, so I'm gonna take my coat off
Yeah.
unless somebody minds.
okay,
And I'm gonna take my shirt off in case somebody doesn't mind, or minds. Okay, go on.
okay, what about wake boat impacts? Hey, I heard of that MLSA.
You heard of them?
Yeah.
Rumor is they're
what can
pretty,
I tell you?
they put on a good conference. Okay, I don't want to say anything. I don't want to say anything, but because I know that we have people here who are not members. So although the conference is free, there are great benefits to joining. Go on, next question.
What about the impact of wake boats?
Well, I believe under Michigan law, you're responsible for your wake right now. So if you are going super fast and you go by somebody's dock and you damage it, you're responsible. But if you remember when we went to the slide proximate cause, what causes it? When a wake boat can be 500 feet away and there's 20 boats on your lake going back and forth, and all of a sudden there's a big wave that damages your dock or your shore, it might be difficult to prove proximate cause between that particular boat and the damage. But I think that anyway, that's the way it is right now. I think it's just a proof problem.
Have you heard of anybody who's had a claim yet regarding a wake boat?
No, not yet.
Yeah. Okay.
And for people, and I just wanted to let people know, for people who don't know about wake boats, the history is that when you were out in California in Malibu and you wanted to ride the waves on coming in as a surfer, if the surf was down, there were people creating boats to make a big wake, to make unnatural waves so that those surfers would always have something to surf. That's why part of the thing with wake boats is the blasting sound, because when you were out there on the ocean off the coast of Malibu, California, you had to have a lot of music. And that has been inherited with wake boats that now are on inland lakes. Next question.
That might have been it. Oh, okay. Let me read this. I haven't read it yet, but our private inland lake has a homeowners association that allows mooring at our association properties. However, our association charges a fee to allow members to moor. What kind of liability does this open our association up to? And as a homeowner who does not want to end up paying a special assessment to pay for a lawsuit, is there a way I may protect myself?
Well, if the association is renting out mooring, there is potential liability. Under Michigan law, there are certain types of, for lack of a better term, certain types of negligence that can be waived. For example, if you're going to jump out of a plane with a parachute, you usually have to sign a release saying, you might die or whatever, which the release may or may not work, but they are typically held valid. So your association, I would recommend, should have releases for the people who are renting to sign, saying what they are being released from. So a release says, in exchange for you allowing me to rent a space or rent a buoy to hook my boat up to, I'm going to give you some money, maybe, to the association, and I'm going to release you, so I'm not going to sue you for certain types of negligence. There's some types of negligence that you can't release. For example, gross negligence, as we talked about at the beginning, you can't release anybody from, but lots of regular negligence, you can sign a release saying, I won't sue you for A, B, C, or D.
Okay, excellent, Mark. No more questions.
Did I mention that you should join MLSA if you're not a member? I just forgot if I said that.
Lots of comments about a lovely shirt. Yeah. Okay. Mark, thanks very much. This was informative for everybody, and we had a good chance to get lots of questions and lots of answers. Folks, I'll let you know that at 4 o'clock, we have another lawyer speaking with us, and that's Cliff Bloom. Many of you have heard Cliff before, and so he's giving us an update like he does each year. And that update will be on riparian rights and laws. And so that'll be at 4 o'clock, and we look forward to seeing you there. Might I say, there's one person named Sylvia who put a question in, and I'll put the link to the answer in the chat. If you stick around, you'll be able to see it in a few minutes when I go find it and put it there. Okay, thanks very much. We'll see you all at Cliff's session at 4 o'clock. Thanks, Mark.